Okay, let's call the first post crossover meeting in the Senate Courts of Justice to order. Clerk will open the roll. Record your attendance.
Mr. Chair, you have a quorum?
Thank you, MJ. Okay, folks, this is the way we're going to run the meeting. We're going to do the cognates first. We're going to do the identical cognates. Oh, actually, we're going to do the identical cognates first. We're going to do those in a block. Then we have some identical cognates that were uncontested. We'll do those in a block. Then we have some identical cognates that were contested. We'll do those each separately. Then we have one that has to go to finance out of those. Then we have a contested bill that's very close to my bill, which we'll take up next. And then we have about 8, 9, probably about 15 new bills. We'll take those up at the end, and we'll go to the sign-up list for that. And before I go to that, I also need a motion to take House Bill 648 from Delegate Corner by for the day. Senator Deeds moves, Senator Bagby seconds. That motion, all those in favor say aye. Aye. All those opposed, no. Okay, that bill's by for the day. So this is what we'll do. House Bill 115 by Delegate Sullivan, House Bill 292 by Delegate Ballard, House Bill 312 by Delegate Gardner, House Bill 444 by Delegate Williams, House Bill 779 by Delegate Carlson, House Bill 833 by Delegate Cousins, and House Bill 836 by Delegate Carlson. All of those are identical to, Cousins. All those are identical to Senate bills that passed unanimously.
Move report.
Second.
Okay, Senator Deeds moves, Senator Obenshain seconds that these bills will be reported in a block. Clerk will open the roll.
Ayes 8, no 0.
Okay, next up, we have House Bill 46 by Delegate Bennett Parker. Firearm transfers to another person from prohibited persons. Delegate Bennett Parker here yet? She's not. This bill is identical to a bill that passed the Senate Bill 47, but it was a contested vote. Yes, Senator Deeds.
Mr. Chair, this is identical to a bill that Senator Favola carried and we passed on the party line. It's basically one that talks about being the right age to purchase a firearm. Everybody's familiar with it. Okay, I move to report.
Senator Deeds moves. Senator Bagby seconds. We report the bill. Clerk will open the roll.
Ayes 6, no 5.
Okay, those. Everybody here yet? 1, 2, 3, 4, 5. No, we still got a majority. Okay. All right. The next one I have is Delegate Henson, 174, which is a bill I think we heard just on Monday about Senator Deeds.
Mr. Chair, this is a bill that we heard from Senator, identical to Senator Evans' bill that talks about the issuance of a marriage license to two people lawfully married adults. We passed it on a party line vote, and I moved to report.
Okay, Senator Deeds moves. Senator Perry seconds that the bill be reported. The clerk will open the roll.
Ayes 6, no 5.
Okay, bill reports 6-5.
Mr. Chairman, the next bill, House Bill 454 from Delegate Carlson is identical to a bill I carried that we voted off the floor yesterday on a party line basis that talks about making a Class 1 misdemeanor to possess a firearm on a college campus. I moved to report.
Okay, Senator Deeds, that needs to go to finance. So Senator Deeds moves. Senator Perry seconds to report the bill, refer it to finance. Clerk will open the roll.
Ayes 6, no 5.
All right, it reports 6-5. Yeah, we need to. Committee needs to go at ease for a second while we get everybody in here to proxy. We don't have a majority right now, Delegate Simon. Hold on. I told him 15 minutes.
Richmond, Virginia.
I know we've lost, well, I had Suas's, proxy. I don't have anything to back.
All right, I guess we'll still suspend.
Oh, okay. I'm giving it to you.
Let's go back again. I have an electric one too, see? Hear it? See? See that?
Much better.
Okay, Delegate.
Matt-
Okay, I'm sorry, Mr. Chairman.
Mr.
One other
Chair.
thing, we have a request from Delegate Simon to take House Bill 184 by for the day. Senator Deeds moves, Bagby seconds. I go by for the day. All those in favor say aye.
Mr. Chair.
Bye for the day.
418, I move to conform to your.
No. Yeah, I'm sorry, you were correct.
418, I move to conform to your Senate Bill 259 and report.
Is there a second to conform? Okay, Senator Deeds moves, Perry seconds. We conform it to the bill we passed, 259. All those in favor say aye. Aye. All those opposed, no. Senator Deeds, you have another motion?
The report.
Okay, Senator Deeds moves, Perry seconds to report the bill. Clerk will open the roll.
Ayes 7, no 6.
7-6. Okay, now, having done all that stuff, it's not going to be as easy for the rest of you. First on my list is Delegate Ballard. Looks like Delegate Weber came instead, though.
I am Delegate Ballard, Mr. Chairman. Making confusion. All right, Mr. Chairman.
294, right?
294, yes, sir. So this is a recommendation from the Committee on District Courts and the Judicial Council, both of those committees. Mr. Chairman, you serve on them, so this should be a softball for you all, reported unanimously. But basically what this bill does, it clarifies that a temporary child support order issued in a family abuse protective order proceeding terminates upon the expiration of the protective order itself or upon the determination of child support pursuant to the code. 20-108.1, whichever occurs first.
Okay, thank you, Delegate Ballard. Is there anybody opposed to this bill? This bill is a recommendation of the Judicial Council and the Committee on District Courts. Passed the House unanimously. Okay, Senator Dees moves, Obenshain seconds to report the bill. Clerk will open the roll.
Ayes 14, no 0.
Thank you, Delegate Ballard.
Thank you, Mr.
I
Chairman.
think it's your only one,
I
right?
like the red jacket, looking good.
Happy Valentine's Day. Huh? No, he's already out. Next up, I have on the list Delegate Williams. Williams, looks like you've got, what is it? What is your bill?
This should be the.
Oh, we
rat
already
bat-
sent you out of here.
Okay, that's already done.
Yeah.
Thank you.
All right, next up, Delegate Srinivasan, 901. He's not here yet, is he? Srinivasan, not here? All right. All right, let's take the majority leader, Delegate Herring. Why don't you come on up? You're standing in for two people, I think, right?
Yes, and I have bills as well.
Oh, okay. What do you want to do first?
This is going to be a, so where would you like?
What
for
do you
me
want to do
start?
first?
Do mine first?
Okay. 774, VASAP local administration fee. I assume the city of Alexandria asked you to do this.
Thank you. Mr. Chair, members of the committee, just a brief background, Virginia Alcohol Safety Action Program provides probationary oversight for persons convicted of DUI. As you know, the ASAP programs are not funded through the state. The current fee structure is $250 to no more than $300 for participation, and there's no really appetite to increase the fee. So this bill would allow localities which significantly supplement their ASAP program the local option to apply an administrative fee to users to help make up their current and often significant shortfalls. An example is Alexandria City, where we're just having problems with funding the program. So again, this is just giving a local option.
Senator Obenchain has a question for you. He had a bill similar to this.
More a comment. I thank the delegate for bringing this bill. I had a bill very similar to this, and frankly, and I've talked with Senator Stewart, who's the chair of the VSAP board, and there is a real problem with the support being provided to local ASAPs. Until this past year, they were getting directly the interlock fees. Were going directly to the local ASAPs. Now they're going to the state. And in 2022, they were making distributions of those funds locally. They stopped doing that. So it's created a real cash crunch for a lot of ASAPs around the Commonwealth of Virginia. I don't know whether this is the way to do it. I had proposed raising the top end of the permissible fee that the courts could award. I support this, but I know there's a diversity of opinion about this. My bill was stricken because of conversation I had with the chair of the VSAP board and the assurance that, the belief I had that the chair understands, and the member, at least maybe one other member of the board, understands the problems that are being faced by the local units, and they're going to look at what is happening with that interlock money and why it is not coming back to local ASAP. So, as I said, I wish the patrons' bill no harm. I support it. But that's what happened with my bill.
Okay.
Mr. Chairman.
Yeah, Senator Stewart.
And that's correct. We did start taking all the fees in collectively to the state and then giving them back out to the programs to try to be fair. And apparently it all hadn't gotten out, but there's a question about that. And we're going to address that, I think, at our next meeting. And Alexandria's in a different situation. I mean, their program nearly shut down, or for all intent and purposes did, and Hampton came in and they revitalized it and got them going again. And it really is because you don't have a lot of use, I guess, more than anything else. And the city refuses to give you all any funding, right? So it's complicated. But again, you're hitting a lot of people who really can't afford to pay this fee, who have to go to VSAP, and it's not voluntary. I mean, we mandate them under the Virginia Code if they're convicted of a DUI to attend VSAP, and so I'm very reluctant to increase the fee. I hope you understand. And we are going to try to address these issues after session at the VSAP meeting to try to help, talk about the formula and how we're doing this, and maybe potential mergers with other localities. That would be some cost savings and everything, but with all due respect to the patron, whom I respect a great deal, I hope we don't increase the fee on the VSAP participants in Alexandria. They're already having a difficult time, and I'd like to explore some better solutions than that.
Okay, I see somebody coming up to testify, so why don't we go 2 and 2? Huh? McDougall, you had something you want to say? Okay. We'll take 2 and 2. In favor?
If there's anyone online that would like
Okay.
to speak in favor, raise your hand.
Hi, Jennifer Vanny, Fairfax County. I just wanted to provide some context because Fairfax also would be affected by this. So it's only localities that pay upwards of 33% of the administrative fees already out of their county or local budgets. Fairfax County currently pays 56% of our own. And so this increase is only going to affect those that the court does not. The court can still waive this and say the client doesn't have to pay. But for people who the court deems are able to fiscally pay for the fee, this would only affect them. So we do support the bill.
Anybody else in favor? ASAP Commission, you guys have a position on this? Is there anybody opposed? Come on up.
If there's anyone online that would like to speak in opposition, please raise your hand.
Good afternoon, Mr. Chair, members of the committee. Christopher Morris with the commission staff. we would go with our chair, Senator Stewart, on this. But Fairfax this year contributed about close to $1 million to their program. Arlington about close to $500,000 to theirs. And Senator Obenshain is correct. We had money coming in that was allocated back to the state office since 2021. And to Senator Stewart's point, a lot of that was used this year and last year in mergers. We were able to merger a couple programs, ASAP programs. So we don't have I would take the position of our chair on this.
We'll see about that. Okay, thank you. All right.
No question. I had a motion.
Okay.
Move to report, refer.
Second. Does that have to go to
Does it have
finance?
to go to finance? Oh, sorry.
No, it does not have to go to
Report,
finance because it's only a local impact.
Report, refer.
I think the suggestion from the ASAP Commission was to carry it over so we could study it along with the bigger problem that's been identified by everybody, and the chairman of the commission just suggested that as well.
It's okay.
Okay. Is there a second?
Second.
Okay. Substitute motion takes priority. Clerk will open a roll. Motion, what is it, carry over to 2025, and with a letter from the chair of the ASAP Commission to look at this as a possible solution.
Ayes 8, no 7.
Okay, Delegate bill carries over with a letter to the ASAP Commission, and we'll be looking at it over the next year, I think. Next up, Delegate Herring, you got 783, recommendation for the Family Law Coalition.
Yes. This is from the Virginia Bar Association. The bill updates adoption laws, making the language gender inclusive to ensure that the rights of parents are protected. And it amends the sections regarding execution of power of attorney to delegate parental or legal custodial powers to include adoptive parents in a direct parental placement adoption and the statutory form. Mr. Chair, I do believe that there have been recommended amendments to the bill by the Department of Social Services.
Yes,
Sabrina?
Mr. Chair, everyone should have them in front of them, and I'll just report them quickly. There are a few, but amendments 3 through 7 are the same, just in different places throughout the bill. So on lines 33, 89, 167, 168, and 169, everywhere that it refers to adoptive parents, it will now read prospective adoptive parents. So we're inserting the word prospective. Also on line 31, after by, BY, insert Romanet 1, and then on line 32, after at sequence, we're going to strike the comma and insert Romanet 2.
Okay, that's Senator Deeds moves, Senator Boyce goes seconds. Do we make the amendments that were suggested by, who was that?
Department of Social.
DFS, Department of Family Services. Okay, all those in favor of the amendment say aye. Aye. Anybody opposed? No. Sorry, there's a no down there somewhere. Okay. So Bill's,
In a yawn, Mr. Chair.
oh, okay. Bill's before us. Okay, is there any opposition to this bill? Doesn't look like it. Okay, Senator Deeds moves, Obenshain seconds, we report the bill. Clerk will open the roll.
Ayes 15, no 0.
Thank you. Delegate Herring, you have 784, I believe. Is that right?
Yes, that is correct, Mr. Chair, members of the committee. This also comes from the Virginia Bar Association in response to the Shell versus Davis case. And essentially, with support orders, there's, typically some courts do a calculation of arrears, and they will do a calculation of overages as well. In that case, the court did not do a calculation. And so it's just make clear to the courts that their calculations, when they are making calculations, can be arrears as well as overages and payment of support.
Okay. And this is also a recommendation of the Family Law Coalition, right?
Yes.
Okay. Is there anybody opposed to this bill? Does not appear so. Senator Perry moves, Senator Deeds seconds, that we report the bill. Clerk will open the roll.
Ayes 15, no zero.
Great. Now, Doug and Herring, you're covering for two other members, right?
That is correct.
Okay, what do you want to take up next?
Let's do HB 1402. I don't know, that is
Which one?
1402. Filling
I don't
in for
see
people.
1402.
Is not docketed today?
No.
Beautiful, thank you.
I thought you were, there's another one
I'll
on.
see you later.
All right.
All right, so then is House Bill 194, yes, House Bill 194. Martinez,
Yeah, Martinez has
Yes.
two. You're doing both of his bills?
yes, let's do that.
Okay, so we're going to talk about the Space Force.
That's right. Basically, it's including the Space Force and the Virginia Military Parents Equal Protection Act. The act currently admits that
Okay.
that force. It's a new service force, and we're just adding it to
All
the
right.
code. This is, again, was a recommendation.
This is central to Delegate Martinez's reelection campaign, right?
It's hey, you know
All
where
right,
he's
anybody
from,
opposed
so.
to the Space Force? Doesn't look like anybody's opposed to the Space Force. Senator Perry moves, Senator Deeds seconds. We report the bill adding the Space Force to this Christmas tree. Clerk will open the roll.
This is our contribution to his reelection effort.
Yes,
Yeah.
thank you.
Okay.
Senator
MJ?
Deeds for Eric.
Oh, you gotta hit your proxies there. There you go.
Ayes 15, no zero.
Great, thank you, MJ. That reports last bill, House Bill 210, electronic execution of estate planning docs.
All right, thank you,
Uniform
Mr.
Wills
Chair,
Act.
and members of the committee. This one I will read the talking points just to make sure everything is covered. The bill does permit trust and advance medical directives and refusals to make anatomical gifts to be signed and notarized as appropriate by electronic means. The bill also codifies the Uniform Electronic Wills Act, which permits a person to execute a will by electronic means. The act retains the core formalities of writing, signature, and attestation, but adapts them for electronic medium. The act requires that it will be signed in the presence of two witnesses who may be physically or electronically present with the testator and acknowledged by the testator and attesting witnesses in the physical or electronic presence of a notary public. Electronic presence is defined, meaning the testator, the witness, and the notary public have to be able to see and watch each other and communicate with each other in real time, just as if they were physically present with one another. This legislation was developed prior to the pandemic by the Uniform Law Commission, but the pandemic underscored the need for this legislation. Making it easier to complete the process of developing and signing a will by eliminating the need for an in-person physical meeting to sign documents will encourage its completion and allow qualified professionals to offer online estate planning services to persons who might not otherwise make a plan. The legislation does not mandate that a person use an electronic will, but gives the option of signing a will by electronic means.
Delegate?
Yes.
We were all up here talking. We remember this bill because we actually PBI'd it in 2021. And I think yeah, we did twice, I think. And I think Delegate Sullivan was carrying it. And this bill might have some heat on it. I think Delegate Martinez might want to present it himself, and we might want to take it up on a more contested docket than this one. Is that okay?
Mr.
Yes,
Mr.
Senator
Chairman,
McDougal.
can I just add, in looking at this, some of us have, and you can take this back, some of us have real concerns about this being abused, particularly with people with maybe still have capacity, but their capacity is not as significant in assisted living facilities. If it was limited to military personnel, you might find some support in that direction.
Yeah, but I don't want to have you, playing
Well, I like
jujitsu
a
on
good
somebody else's.
conversation, so I'm up for it, but is the chair, if you prefer that we not proceed?
Well, we were trying to take up less controversial bills today.
Okay.
And,
I got it.
And I
was ready, but I
do it
got it.
now?
I understand.
Wait, hold on. Well, you want to do it now?
Mr. Chairman, I think the intention is to be courteous to
Yeah, no, that's
Delegate
fine.
Martinez. If
Yes, that's fine.
they would rather be here.
That is fine. That's fine.
Okay.
Follow the committee. Thank you.
Okay. Yes, Senator Bagby.
Mr. Chair, I would be, it would be lost time if we could probably hear from Senator McDougal on the issues, and maybe that may be helpful as Martinez comes back to listen to
Yeah.
this communication.
Mr.
Mr. Chairman,
Senator McDougal.
I don't want to steal Senator Obenshain's thunder, but I think what many of us have concerns about is if it's an electronic signature, if it's in person, the witnesses are there, the case law is pretty clear on what a individual executing a will has to know. They have to know the object of their family, their progeny. They have to know their assets, and they have to be of sound mind and body. And sometimes in the practice of law, you've seen family members that try to get attorneys to execute wills that would shift assets to other family members against the interest of that individual. And maybe if they're not in their full capacity, that could be a challenge. And unfortunately, my family went through this. There's a Supreme Court case, McDougal v. McDougal, where it did not go so well. So we have had some personal interest in it. And that's why if this was focused on active military members, if that's the goal, I think that alleviates 90% of the concern. So we could probably get there.
Mr. Chair.
For me, maybe not Senator Obenshain.
Senator Bagby.
Mr. Chair, I was see that that's extremely helpful. I would ask Senator Obenshain to do the same.
Yeah.
Mr. Chair, we've talked about this over the past several years, and one of the issues that I care deeply about is financial exploitation of elders. And there are certain things that can be done safely online, and other things that really need to be done in person. Financial exploitation in the wills, trusts, and estates area takes many forms. And in this instance, there's no telling who's in the room. While the witnesses may be in the room, there may be somebody else in the room who may be exerting influence. There's really no substitute for an attorney being able to sit down across the table one-on-one with the testator or the maker of a trust without witnesses, being able to ask them, what do you really want? Rather than ask them the rote questions that are necessary to execute a will. It just, to me, has always been an area that opens this up for further abuse and exploitation.
Thank you.
Bagby, got it? Yeah, Senator Bagby.
Do you need a motion?
Sure.
A motion for this bill to go by for today?
Yeah, that's it. Senator Bagby moves there in seconds. The bill go by for the day. Delegate Herring, if you could communicate some of that to Delegate Martinez.
I will definitely do so. Thank you, Mr.
And I'm
Chair,
sure
members.
Delegate Sullivan, who's sitting there watching, can tell Delegate Martinez about his experience here 2 years ago.
Ooh, all right. Thank you so much.
Yeah. Thank you, Delegate. Next up on my list, I've got, is there anybody behind the podium? Is Bennett Parker here yet? No. Okay, then we got Henson. Huh?
House Bill 174 you already passed in a block.
Oh, we already took you by for the day? You don't have another one? I know, I see. He wasn't here. Yeah. So, Doug, okay, you're on the list, but we already took care of yours, right? Okay, you're just watching? Oh, okay. I didn't know we were so entertaining in here. Srinivasan, you made it back. So why don't we take your 901?
Thank you, Mr. Chairman, and the members of the committee. I'm here for my HB 901 bill. It's a recommendation of the Boyd Graves Conference to clarify that parties need not move for endless reconsideration of rulings, particularly pretrial rulings, in order to preserve their appeal rights. This bill addresses a problem created by the Supreme Court's opinion in Lucas versus River Hill Poultry. In that case, the court ruled that by failing to move for reconsideration of a pretrial ruling during the actual trial, the party had abandoned the issue for the
Delegate, yeah, I think a lot of us up here understand the bill. Basically, it just says that you don't have to file a motion to reconsideration to preserve an error if you've already objected to it on the record.
Yes,
and I think you said Boyd Graves recommended it?
Yes, sir.
Okay. Is there anybody in opposition to the bill? Doesn't see anybody in opposition. We have a motion to. Okay, it's been moved and seconded. We report the bill. Clerk will open the roll.
Ayes 15, no zero.
Thank you, Mr.
There you go.
Chairman
No
and the
problem.
committee members. Really
Didn't think you were going to use that speech for YouTube or anything, so move
Thank
along. Yeah, okay. Okay.
Thank you for your consideration.
No problem. Thank you, Delegate. Welcome to the committee. Next up, we have Delegate, is Bennett Parker here? No. Then Levere Bowling. And you've got 934, right?
Yes, House Bill 934,
And
Mr. Chair.
you just want to make it so that LLCs can come to small claims courts like corporations, right?
Correct, and it is the recommendation of the Boyd Graves Conference.
Okay, more controversial bills. Is there anybody opposed to this bill? It's been moved and seconded. We report the bill. Clerk will open the roll. Notwithstanding Bagby's grunt. Was it somebody else had a question down there? No, it's the green button. Okay.
Mr. Chairman.
All right, hold on.
Mr. Chairman,
Senator
I was just going to welcome her to the General Assembly and the Courts Committee because she's from King George County, and I knew her when she was a child. She was a good kid and a smart kid, too.
Thank you.
All right, clerk will open the roll. How we doing?
Ayes 15, no zero.
Okay. Reports. Welcome to the Courts Committee, Delegate Levere Bowling.
Thank you.
Happy Valentine's Day.
Same to you.
All right. Next, Bennett Parker's, we've already taken care of, so we just need to take her off the list. Delegate Cousins. We already took care of her bill, too, didn't we? Hey, Cousins, I think we already took care of you. You had two.
Okay.
We already, before you got here, we sent them on their way.
Perfect.
You're done.
I was expecting hypotheticals on rule against perpetuity, so.
Yeah. Yeah, and Bennett Parker, we took care of your bill too. I kept calling you because your name is on here. I guess your staff put it on, so I think you're done.
We took care of it.
Yeah. Okay. Next on my list. We can do Simon's bill really quick. Didn't we already do Simon's?
We've already done Simon.
Oh.
Well, this bill's go about for the day.
We didn't do. Well, we didn't do 259 yet, right? Class actions. We didn't.
We conformed it.
We did that. Okay. So 184 is by. So that leaves Sullivan. You got 110, and that's it.
Yes, we already did 115, Mr. Chair.
Yep.
I think Delegate Martinez was just hoping a different face would get a different reaction to that bill. Mr. Chair, members of the committee, HB 110 relates to surrogacy in Virginia. It was 33 years ago when Virginia became one of the first states to adopt a law overseeing surrogacy. And this, of course, is for helping Virginians who want to start or grow their families have a child through a surrogate. At the time, it was new, sort of cutting-edge health care, a new cutting-edge health care option. And Virginia is still one of only 20 states or so which have such laws. And Virginia's statute and rules are among the most extensive and detailed in the country, particularly with regard to the protecting the interests of the woman who's going to serve as the carrier. Between our statute and the strict guidelines of the American Society for Reproductive Medicine, for instance, Mr. Chair, there's a statutory prohibition on compensating the carrier beyond her reasonable and ancillary costs. And the statute makes very clear that any surrogacy contract providing her compensation beyond that is void and unenforceable. There's an extensive psychological evaluation required and professional counseling of all the parties and a specific assessment by a mental health professional to ensure there's been no financial or emotional coercion of the carrier. The carrier also has to have independent legal counsel from the very start of the arrangement through the pregnancy and the parentage part. So none of these protections of the carrier or the many others that we have in the statute are changed by HB 110. What HB 110 does is remove one portion of the surrogacy code which is outdated, has never been used, and is the only one of its kind in the country. No other state has this statute. Most importantly, Mr. Chair and members of the committee, and the problem that this bill is meant to solve is that this portion of the code has the unintended consequence of chilling Virginia families' access to surrogacy. What Section 110 would repeal is Section 20-165, and that creates a crime for accepting compensation for matching prospective parents with prospective surrogates and for arranging for prospective parents and surrogates to enter into a surrogacy contract. Yet, of course, that's precisely what the rest of the statute provides, how prospective parents and surrogates can enter into such a contract and what that contract has to include. So, Mr. Chair, the statute creates a sort of internal inconsistent gray area which has the effect of frightening off potential parents
her worried about being implicated in some sort of crime or aiding and abetting the commission of a crime when the lawyers, as is their obligation, have to tell these parents about the existence of this statute. It creates confusion and uncertainty for Virginians who want to expand their families. And, Mr. Chairman, that uncertainty has led a number of national surrogacy groups which help potential parents navigate surrogacy laws rate Virginia as among the worst states for surrogacy in the country. This statute, I want to say again, has never been used in Virginia. The bill has no opposition from law enforcement or from the Attorney
Is there any
General or from the
opposition to the
Commonwealth.
bill at all? There's, okay, the Catholic Conference wants to speak. Two on each side. Okay.
Mr. Chairman, my name is Tom Antorsi. I'm with the Virginia Catholic Conference, as you stated, and we are opposed to this bill primarily because the wisdom of the General Assembly, when it enacted Code Section 20-165, was such that the General Assembly made a policy decision not to authorize commercial brokers to participate in gestational surrogacy. We now have gestational surrogacy in Virginia. And so they did that with good reason. And the reason that they did that was because, and the statute is very plain, it says that it is unlawful for any person, firm, corporation, partnership, or other entity to accept compensation for recruiting or procuring surrogates or to accept compensation for otherwise arranging or inducing.
Isn't it so that nobody's ever been prosecuted under this code section?
You know, sir, I can't speak to that. I'd have to ask VACA about that.
Okay.
But what I can say is that the provision carries with it both a criminal penalty and a civil liability provision as well, treble damages.
It's never been utilized.
And there again, I can't speak to that, sir. Only VACA could speak to that. Okay. But I respect the question. Okay, I think it's a fair question. Thank you. So that's in Part A. Is it talks about, you know, you can't procure surrogates. Brokers cannot procure surrogates. And if you do so, it's a Class 1 misdemeanor. In Sub B, it says that any person who acts as a surrogate broker in violation of this section shall, in addition, be liable to all the parties to the purported surrogacy contract in a total amount equal to 3 times the amount of compensation to have been paid to the broker pursuant to the contract, okay, and et cetera. So that's a treble damages, right? So, but the key language that I want to focus in here is to accept compensation for, pardon me, I'll wrap up. Okay. To accept compensation for recruiting or procuring surrogates or to accept compensation for otherwise arranging or inducing. That's the key word in this statute. We don't want brokers inducing surrogacy contracts.
It's true that no other state has this language as in effect.
We're a yellow. Let me answer your question, Mr. Chair. We are what is defined as a yellow light jurisdiction in gestational surrogacy. We're not the worst. We're somewhere in the middle. And I think most people would agree that being in the middle is a good place to be, and we should stay there.
But we're the only state with this sort of provision.
We are not the only state with limits on commercial surrogacy, sir. Okay. And I can show you that from a site that I've been referring to.
Okay, thank you so much.
Absolutely, sir. Thank you.
And we're out of time, so just come up, and if you've got something different to say, you can say it, but otherwise just identify yourself and your group.
Yes, Mr. Chair, members of the committee, of course, I'm Olivia Turner, president of Virginia Society of Human Life. We are not taking a position for or against surrogacy. We are concerned for women in the Commonwealth and families who may find themselves in situations where they do need to have access to some kind of financial gain or situation that they benefit from. The brokers will ultimately be in a situation that we think could lead ultimately, sadly, to violations of human trafficking. There are vulnerable populations now coming into Virginia. There are populations that don't speak the language very well of English as their common language. My concern is for women. My concern is always for the women, and my concern is also for the couples who may find themselves being manipulated by brokers and those recruiting women who are too vulnerable to know what our laws actually are.
Okay.
So
Thank
that's
you,
our
ma'am.
concern.
Thank you, ma'am. Next. Please, only if you have something different.
Well, and we agree with those comments. I just want to make just three very brief.
Identify yourself and your group first.
Todd Gackey on behalf of the Family Foundation. One is within this bill, there is no limits on the amount that these organizations can help or can charge in facilitating these surrogacy contracts, which could lead to coercion and exploitation. The second is there are nonprofits out there that help do this, so there is no need to put in place some type of monetary. Okay. And we think that the provisions that were put in place in 1991 were for a good reason, and we would ask that this body not change that.
Thank you so much. Delegate Sullivan, am I right that no other state does it like this?
That is correct.
No other state has this kind of language on the books.
That is correct, Mr. Chair. By the way, I have a subject matter expert with me.
I understand there's somebody else. And
Mr. Chairman.
Senator Stewart.
Can I just ask Rip to address what they said about the concerns of taking advantage of folks and human trafficking? And can you address that for me?
Yes, Mr. Chairman, I'd be happy to. As I tried to indicate in my opening remarks, our bill is probably better than any state in the country on protecting the rights of a woman who is going to serve as a carrier. She has to have counseling. She has to have her own lawyer. There's a team of people that make sure she is not being coerced into doing this. She is not allowed to be paid any more than her own expenses. And if she is, the contract goes kaflooey. And so the parents these of course are parents who want this child. The parents are going to make sure that doesn't happen as well. So there are a lot of protections for the carrier built into our statute already. And what this does is stand as a roadblock to people using it.
Mr. Chairman.
Well, if he's finished, I appreciate him responding to that.
Yeah.
That was the only question I have, but I'd like to let Delegate Sullivan finish his response.
I did have one other point. Thank you, Mr. Chairman and Senator Stewart. I don't doubt the motivations of the General Assembly 33 years ago, but then was the very beginning. People were just sort of inventing surrogacy. And we live in a very different time now. There are 800 facilities around the country that do this, and the specialty that is surrogacy and in vitro and all those sorts of assistance to couples is a specialty that's matured. This is a medical specialty. No other state has seen any bad behavior associated with this. Our statute protects these women. And we want to be able to encourage surrogacy rather than discourage it, and that's why I hope you'll pass this bill.
Okay, Senator McDougall.
Mr. Chairman, tell me, do any other states have a prohibition on the brokerage? I think I don't want to speak for everybody, but I think many of us see the benefits of surrogacy and how for a number of people that can be the only way. But the concern is around the brokers. So do any other states prohibit brokers?
Mr. Chairman, my understanding, Senator, is the answer is no. No other state has, and so 49 other states, the District of Columbia, have been doing this for a long, long time. No one has, the way I look at it is no one has felt the need to replicate our statute, has seen this as a problem anywhere. And if you look at the statute and read it carefully, broker, by the way, is only one way they describe it. What it says is, except any compensation, someone mentioned nonprofits. The only compensation here, doctors who do this get compensated in the way that your heart surgeon gets compensated when he or she operates on your heart, or when your internist gets compensated when they prescribe you medicine. They provide a medical service. and they get compensated for it. What it says is to accept compensation or arrange an intended parent and surrogate to enter into a surrogacy contract. That's what these people do, is they help parents and a surrogate enter into a contract and perform this little miracle. And this statute makes people take pause here in Virginia and, frankly, go other places to accomplish the same thing.
Okay, I think there's another question that was hand raised. Peak?
Mr. Chair, of the Delegate Sullivan, has anybody raised a concern about this? Has it come up from a group or any entity? How'd you get this?
Mr. Chairman, thank you, Senator Peake. The answer to that is yes. I'm not here to tell you that any particular, that I'm coming with the imprimatur of a particular group, but this is an issue, and I do have someone I know the committee will want to hear from, who talks and will tell the committee about clients that she has to counsel. Frankly, any client would be concerned about that, but consider someone, for instance, with a security clearance or some other sensitive job, or anybody, a teacher. And when you have to counsel this couple, if you want to do this, I have to tell you, there's this statute that says this is a crime, or this whole, someone helping you accomplish a surrogacy contract is a crime. Never been done before, but it's out there. People get nervous and are concerned that they cannot do this. And I'd love to hear Ms. Quinn tell you better than I. But that Senator Peake is why I'm here. I'm trying to make sure that everyone has their chance if they want it.
Senator Stanley, do you have a question? Senator Deeds mentioned you might have had one while I was gone.
Mr. Chairman, it was answered in the conversation. Thank you.
Great. My understanding is we haven't taken support yet, right?
Yeah, Colleen Quinn is with me here, Mr. Chair, who I think it's fair to say is the state's premier authority on all things adoption and surrogacy.
Yep. Did we set it, what, 2 minutes before?
2 minutes plus, there was 2 minutes and 18 seconds.
Okay, yeah, set it whatever we just did for opposition. Ms. Quinn, come on up. I was wondering why I saw you here last week, 2 weeks ago.
Good afternoon, Chairman Sorrell and fellow committee members. My name is Colleen Quinn. I'm the former president of the Academy of Adoption and Assisted Reproduction Attorneys, which is the national and international academy in this area. I also have been in practice in Richmond for 35 years. I run the Adoption Surrogacy Law Center. I teach nationally on surrogacy, and I've worked with literally thousands and thousands of clients seeking to build their families. I just wanted to give you one quick, simple example of the adverse impact that this statute has. First of all, I want to tell you this provision is simply not enforced. I've spoken to numerous Commonwealth attorneys, including Colette McKeechin here in Richmond, Shannon Taylor in Henrico. They're not aware of the statute. They're not interested in the statute. They don't want to enforce the statute. It's simply not enforced, and we have more than 800 programs throughout the United States, including in Virginia, operating and making sure that intended parents can connect with surrogates. By way of a quick example, I met with a couple just within the last few weeks. Dr. Anish Shaw at Shady Grove sent them over to me. He told them to come to me first before doing anything else, but they had signed up with Fairfax Surrogacy. When they came to me, I told them about this statute. The intended mother had a cancer. She had a hysterectomy. She was unable to carry a child herself. The intended father had a high-level security clearance with the government. And when I told them that technically they were aiding and abetting and accomplices in this statute, which all my Commonwealth attorney friends say my interpretation is correct, the intended father, he began to freak out because of his high-level security clearance. And this is what the statute does. It has the effect of chilling our families from being able to find somebody to carry a child for them. As Delegate Sullivan already said, our statute is the most conservative. It is still good. We're still going to be a yellow state. And by the way, 45 or 46% of the other states, 46 states are green states, okay? So we're in the minority, and we're going to stay in the minority. Even if we take this away, we still have enormous restrictions on what can be reimbursed to a carrier. It's not going to change. We're going to still be very conservative. But on this Valentine's Day, I would say please show your love for Virginia citizens. These folks are facing fertility issues, being able to build their families, and they don't need this added stress. This is already a very stressful process for them. So please show your love and support House Bill 110, and if there are any questions, I'm happy to take them.
All right, we got a minute 45 left. Anybody have any questions for this expert? Doesn't look like it. Thank you, Ms. Quinn.
Thank you, Delegate.
Is there anybody else here to
Chairman
testify in
Sullivan.
favor? Anybody online in favor?
Mr. Chair, there's no one online to speak at this time.
I didn't think to invoke Valentine's Day.
You're welcome. All right. It's been moved by Senator Deed, seconded by Senator Boysko. We report the bills. Any further discussion? Clerk will open the roll.
Ayes 10, noes 5.
There you go, Delegate Sullivan.
Thank you, Mr. Chair and members of the committee.
All right, next up I have Delegate Delaney. 769, trying to give the Attorney General more persecutions, right?
Well, Mr. Chair, hello. Good to see everyone today. I have HB 769. This is a recommendation of the Virginia Criminal Justice Conference. This bill, what it does is it allows crimes of financial exploitation and abuse and neglect of vulnerable adults to be investigated by multi-jurisdictional grand juries. What was identified was that there's some jurisdictions, predominantly in rural areas, that are experiencing difficulties with their grand juries investigating instances of financial exploitation and abuse. And these grand juries, they only meet 4 times a year, so the victims and witnesses of these crimes sometimes are incapacitated. It's challenging to have them appear multiple times, and sometimes time is of the essence. So adding these crimes to the list that can be investigated by the already established multi-jurisdictional grand juries allows these localities to investigate the crimes in a more timely manner. They meet more regularly, oftentimes twice a month, and are therefore better positioned to hear this critical testimony. One of the things I found most interesting when this bill was brought to me is, we know that there's a lot of opinions about the use of multi-jurisdictional grand juries, but just to make note that they are currently able to investigate Medicaid fraud relating to nursing home residents, but not the physical abuse of that resident. And additionally, they are able to investigate animal abuse, but not elder abuse. So I do think that there is a correlation in where we see the value of this tool, and that this is a natural extension of that.
All right, thank you, Delegate. Historically, we've tended to resist a lot of these, but I think we need to hear some testimony about it. We have, I think Delegate Bagby had one of these, or when he was a delegate, had one of these about 3 years ago, I remember. So why don't we do, I don't know, 2 and 2? Are you Attorney General or Vaca? Come on up. You have a question? You have a question?
First, this is a VCJC recommendation, isn't it?
Yep, it is.
For those who aren't acquainted, that's the kind of Boyd Graves Conference of the criminal bar, the prosecutors and defense lawyers.
And Mr. Chairman?
Senator Stewart.
I will also tell you there's probably nobody up here who hates the Christmas tree of multi-jurisdictional grand jurisdiction of grand juries than I do. But I do see a big need for this particular issue. And so I just say that I don't relent very often on these, but I think she's identified an area we probably should consider this.
Okay. Okay. But no questions for Delegate Delaney. Okay. So why don't you come on up? Happy Valentine's Day. Welcome to courts.
Thank you, Mr. Chairman, members of the committee. I'm John Childrey of the Attorney General's office. The Attorney General does support this bill. I'll tell the committee for 3 years, almost 3 years, I was counsel to a multi-jurisdiction grand jury, and I also served on the VCJC for a period of about 4 years. So I'll be happy to answer any questions from the committee about either of those entities. But as to this bill, as our population gets older and there's more vulnerable adults that are subjected to abuse and neglect and also financial exploitation, This would allow this very powerful, the investigative tools of the multi-jurisdiction grand jury, the ability to subpoena people pre-indictment, to find out more about what has happened, or to issue subpoenas ducis tecum to gather information. Those powerful tools, we believe, should be available to combat these growing crimes of elder abuse and financial exploitation. As the delegate pointed out, there are some discrepancies kind of jurisdictionally in the current makeup of what the multi-jurisdiction grand jury can do, and this bill would alleviate some of those disparities in the opinion of the Attorney General. I'm happy to answer any questions. Thank you.
Great. What are some of the limitations you all have seen in some of these other localities as to why Delegate Delaney hinted at it? But I mean, do you have any? Is it the big counties, little counties? I mean, what? I assume it's a little.
Multi-jurisdiction grand juries, and Mr. Chairman, you mentioned the Attorney General's more prosecutions. The multi-jurisdiction grand jury really has little to do with the Attorney General's office. It's conglomerates of jurisdictions that impanel a grand jury, and some of these grand juries meet for years and years and years, and they allow the member jurisdictions to employ the tools to investigate the crimes that are part of this bill, or part of the statute, that happen in those jurisdictions. Now, some of the jurisdictional avenues are as to crimes that cover more than one jurisdiction, and folks seem to see a match between those and the multi-jurisdiction grand jury, but not all of them. Many of them are very discrete crimes, and it just allows a investigation to take place pre-charge for all of the jurisdictions that make part of each of these grand juries. And there are some communities in Virginia that don't have the benefits of a multi-jurisdiction grand jury, but fortunately they are active in parts of Virginia, and where they are active, they are effective.
One of them up there I know is run by an assistant attorney general.
The Attorney General's office has been involved in setting up multi-jurisdiction grand juries, yes, sir. And the reason is because they are effective. Other than a special grand jury, there's really no investigative grand jury in Virginia. And special grand juries, as you might know, really focus on one crime. And multi-jurisdiction grand juries can sit over several years and help communities solve all of these sorts of crimes.
Okay, but you're saying they don't all have to be Attorney General run things, right?
That's correct.
Okay. Is there anybody else in favor? It is not. Okay.
Mr. Chairman.
Yeah, go ahead.
Tim Coyne, I'm the Deputy Executive Director of the Virginia Indigent Defense Commission, also a member of VCJC. And this was a VCJC bill. It follows up on several years. Senator Obenchaine's carried some bills for us to address elder abuse and vulnerable adults. This was just an extension, was not targeted or designed to expand the power of the Attorney General, but just to recognize that in many of these cases crosses jurisdictional lines, and to just allow the investigation of those matters.
Okay. All right. Let's reset the timer. I'm sorry, anybody online in favor? Nope. Okay, we reset the timer. Is there anybody opposed to the bill? Is anybody online opposed to the bill? Okay, it's been moved and seconded. We report the bill. Clerk will open. Oh, I'm sorry. Been moved and seconded. We report and refer the bill to finance. Clerk will open the roll.
Ayes 15, no 0.
Very persuasive, Delegate Delaney.
Thank you, Mr. Chair, and thank you, Senators. It's great to see you all.
Okay, then now we have Delegate Arnold. You've got a whole bunch of them. 4.
Afternoon, Senator, Mr. Chair.
What would you like to listen to do in order?
Dealer's choice, Mr. Chair.
All right, let's do 430 then.
All right. Mr. Chair, members of the committee, HB 430 simply requires that the pretrial service officer, if they send a report of violation to someone who is under their custody and supervision, they also send that report to the local Commonwealth Attorney and Defense Counsel of record. This bill came out unanimous from the House. I'd see how y'all take that.
Yeah.
It's first time. I'm just trying to.
We've killed a lot of
unanimous
House
just
bills in this committee.
Just feeling you, Senator.
All right. Counsel, did you have a question about this one?
I'm sorry?
Did you have a question about this one?
No question. The only technical suggestion we had was to change the word, this is on line 77, change the word such to a, and after the word violation, add of a condition of release, of any condition of release. I think that's consistent with
You think that makes it clear, Mr. Benjamin?
Pardon me?
You think that makes it a little clearer?
I do.
Yeah, I'd be a friend with
Mr.
him.
Chairman,
Senator Perry.
if I could just comment on that language of a condition of release, I'll just point out to the members of the committee that the court can set certain conditions. Sometimes they are comply with probation, and then you go to probation and you sign the terms and conditions of probation. So I don't know if those are terms of release. They're probably not, but they're terms of probation.
And
Senator, Mr. Benjamin, you thought about that?
I think by probation, what we mean is pretrial services, which may be probation officers.
It's the same.
Senator Perry.
Mr. Chairman, it's the same point. I used to be a pretrial officer. It's the same point. The terms of pretrial, that's fine. It works in the same fashion.
So, Mr. Benjamin, they would say as a condition of pretrial release?
Yes. Yes, Mr. Chairman. That's correct.
Okay. Delegate, you think that's a friendly amendment?
I do so, Mr. Chair.
Okay, Senator Deeds moves, Senator Boysko seconds, that we make the amendment suggested by Mr. Benjamin. All those in favor say aye. 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 Anybody opposed? No. Okay. Is there anybody opposed to this bill?
Move to report.
Second.
And this does not have to go to finance. So, okay, it's been moved and seconded the bill be reported. Clerk will open the roll.
Ayes 15, no zero.
All right, Delegate, next up, you got 432 about making a jury list available to council.
Yes, Mr. Chair. Members of the committee, HB 432 increases the time from 3 full business days to 5 full business days from when the clerk shall release the jury panel to council.
Is anybody from the clerk's office, Hopkins, you guys got a problem with this? We don't. Okay. So more notice to the defendant of who's going to be on their jury.
I've moved it out for 10 days.
I originally had 14, but I thought that was a bit much.
Mr. Chairman,
yeah, Mr. Benjamin.
Let me just add that I think in some jurisdictions, the problem that I've heard of is that the panel can't be provided or isn't provided even 3 days ahead of time. I also understand, this is anecdotally, that motions to continue aren't being necessarily granted. And so while I think that expanding the requirement to 5 days or whatever certainly helps send the message that the General Assembly means this, I don't know that it's going to help the problem in those problematic jurisdictions because there's no sanction, no remedy here.
Got it. Senator Deeds has a comment on that, I think.
Just move to report.
Where are the
Offline, I want to know where those problematic continuing cases, another error for an appeals court to consider, right?
Mr. Chairman, the question is
Mr. Bennett.
whether a denial of a continuance would represent an assignment of error for an appellate court, and that would be a loser, in my opinion, because it's a discretionary call by the judge, unless you provide otherwise.
Senator
For
Deeds.
example, Mr. Chairman, the committee could require that if the panel isn't provided in time, then the parties shall be entitled to a continuance as a matter of right. And you could go further and say a denial of such continuance shall constitute reversible error. Mr.
That only appears in one statute in the books that I'm aware of. And that's
Well, I like that statute, Mr. Chairman. But
Mr. Obenchain.
These are just what's available to the committee, that's all.
Moreover, the current statute doesn't expressly state this, but it sure indicates that it is not grounds for a mistrial and it is not assignable as error on appeal. That refers to the accuracy of the information. So if they leave off the name of a juror who shows up on the final list on the day of trial, it's not. But I think a court would be hard pressed to not extend that to disclosing that list 4 days or 3 days as opposed to 5.
I agree, Mr. Chairman.
Okay, does anybody have any other questions about this bill? Any further thoughts about it? You want to add the continuance?
Why don't we just add the continuance language?
Mr. Chairman, that's correct. You could add that.
Wouldn't it say that failure to provide the list in this time frame shall constitute good cause for purposes of a continuance? Or no? Yeah, Senator Obenshain.
I would caution, I would caution those civil litigators in here that is a sword that I'm not sure that we want to provide, because there's a push and pull. Plaintiffs in civil litigation want to get their cases tried. Insurance companies and defendants do not. And I don't know that justice is served by letting people play games with that.
Mr. Chairman, I think that's right, and we had that consideration. It may be appropriate to say a criminal defendant shall be entitled to a continuance as a matter of right.
You could add a sanction for the clerk.
Because they're the locked up ones.
I think the clerk will change their position on the bill if we do that, Senator. Senator Deeds, you have a thought?
I just move the report the way it is.
And I will second it again.
Okay. It's been moved and seconded to report the bill. Any further discussion? Clerk will open the roll.
Ayes 15, no zero.
And Delegate Arnold, I think there's maybe an idea in there for maybe a bill to take a shot at next year if you're looking for something to do.
Thank you, Mr. Chair.
All right. You got a cognate patron over there. House Bill 436.
Yes, Mr. Chairman, members of the committee. This bill involves the Health Care Decisions Act, and what the bill does is basically, if there is an action filed for divorce or annulment of the marriage between the declarant and the named agent, or a petition for custody visitation of a child of the declarant and agent, that would automatically revoke the executed advance directive.
Thank you. Delegate, sorry, there's...
What was my bill?
Yeah.
I don't know. What are you guys doing? This involves advance directives. So basically, right now, if you don't have an advance directive and there's no custodian of the person, it goes to the spouse unless there is a divorce complaint filed between the spouse and the person who's needed the care. What my bill does is basically says if there's an executed advance directive, subsequent to that, there is a complaint for divorce filed between the declarant and the named agent, or a petition for custody and visitation between the declarant and named agent concerning their child, it automatically revokes the executed advance directive.
One second, Delegate. This is where it already does this. Okay. All right, are there any questions for Delegate Arnold? So, Delegate, I think what we've been told is that this is already, filing a divorce or custody case already automatically terminates uniform, I guess, powers of attorney, revocable trusts, and under the Health Care Decisions Act, that authority terminates if there's no advance directive. So there's already some precedent for doing this in some other legal areas. Mm-hmm. Is that right?
Yes, my understanding.
Okay. So and this basically would be if you file for your divorce, your estranged spouse can't make medical decisions for you. It's basically what this does, right?
That's basically what it says.
Pull the plug.
Okay. Pull the plug, right. Okay. So any further discussion? Anybody opposed to this bill?
Mr. Chair, there is one person online that would like to speak. Stephen Burns, you may
Why don't we
unmute
set
and
the
please
timer
make sure your
to
camera's
2?
on.
Is this person in support or against? We don't know? Okay.
Mr. Chair, Stephen Burns, on behalf of the Virginia Academy of Elder Law Attorneys. We had sent in some comments. We believe that the bill needs some clarification or an adjustment. As written, it would terminate the entire document. So as you know, you might appoint your spouse might be your primary agent, but you could have a sibling or an adult child as your backup agent. So if the entire document is revoked, then we are relying on either a guardianship proceeding or...
Sir, I think what you're saying, though, is that we could clarify it to say that any authority in the document as to the estranged spouse would be terminated, but not the kids, right?
Well, so under the Uniform Power of Attorney Act, it simply terminates the authority of the agent. So here, we would terminate the authority of the divorced or separated spouse.
Any successor would survive.
And
That makes sense.
And
Okay.
this is an issue that Senator Obenshain, a couple years ago with his financial exploitation bill, we adjusted it so that now it's under the Uniform Power of Attorney Act that the agent's authority terminates, not the entire document.
Right.
Okay, thank you. I think that makes some sense. Counsel, Sabrina, can you
Yeah.
recommend a fix for that?
Yes, Mr. Chair. So we could use the language or mimic some of the language from the power of attorney section. So that's 64.2, 1608 in subdivision B3. So in HB 436, we would insert on line 23 after A1. We could strike some of the language on there. I think probably that first clause. So if after executing an advance directive, or actually, I guess we could keep that and say unless the advance directive otherwise provides. And so insert that before the Romanettes.
Sorry, how would that solve that problem?
Because then oh, I see. Okay, so that would at least allow for the declarant to explicitly state whether or not they have another power of attorney, or excuse me, another agent under their advanced directive. And then we could.
Wouldn't you just rewrite it to say that instead of it being written like this, sort of write it in an active tone instead of a passive tone, where you'd say the filing of an action for divorce or annulment or a petition for custody or visitation of a child of the declarant agent shall terminate the authority of the party, opposing party to the action, or something like that?
Yes, Mr. Chair. So we could,
I think that would probably fix it.
yeah, on line 25, then we could strike.
I think you rewrite the whole sentence and just do what I just said. I think that would solve the problem.
Okay.
Right?
Thanks, Mr.
I
Chair.
move the amendment in concept.
Okay, it's been moved and seconded in concept that we do that. You're cool with that?
That's
Okay. We'll tweak it up and you'll see it before it
Conceptual.
hits the floor. Okay, all those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Okay, now, it's been moved and seconded by Perry and Obenshain that we report the bill. Clerk will open the roll.
Ayes 15, no zero.
Your bill reports, Delegate Arnold. You have one more, I think, right?
That's correct, Mr.
438?
Yes, sir.
Yeah. Yeah, really. First trip here and he gets 4 bills. Freshman in the minority. What in the world?
Thank you, Mr. Chair.
Losing our will here.
No. You guys are a fun lot.
All right, what does this one do?
What this bill does is it requires a written criminal complaint for any felony warrant, regardless of whether or not the complainant is a law enforcement officer. Right now, currently, where I practice and what I'm hearing from other attorneys is some jurisdictions, the police are instructed to do a written criminal complaint and others do not. This would require it for any felony warrant.
We don't have in Northern Virginia. Not on felonies. Written criminal complaints on felonies? I never see them in Fairfax. Maybe Loudoun's different. Okay, Senator Perry. Huh? Wow. Lucky Loudon. Okay. Okay. Any other questions for Delegate Arnold? Is there anybody in opposition to the bill?
In full candor, the Sheriff's Association came to subcommittee and briefed a minute opposition to it.
They were good. Okay. Doesn't look like anybody's opposed to it. Seems like a good idea to me. All right.
Report.
Okay, it's been moved and seconded. We report the bill. This is the best day Delegate Arnold's ever going to have in this committee. Clerk will open the roll.
I know, it's all downhill from here, right?
Ayes 15, no zero.
All
Thank
right.
you, Mr. Chair,
Your
members
bill
of the-
reports. Yeah. What? Oh, we didn't do that one? Okay, Delegate Herring, come on up. We forgot to do one you were supposed to do. 414, Converse Fowler, land records,
Yes.
recording fees.
Yes. Thank you so much, Mr. Chair, members of the committee. The legislation as brought to you today, will bring much needed standardization and uniformity to the recording and fees for various commercial filings, such as deeds of trust, quitclaim deeds, and certain uniform commercial code filings. This is a recommendation from the Virginia Bar Association's Real Estate and Land Use section, and it has been vetted with the Virginia Clerks Association, which supports these revisions. And the problem we're trying to solve is that clerks in various jurisdictions and sometimes their deputies within those offices are handling certain commercial filings in highly inconsistent ways and charging filing fees in unpredictable ways.
So
This
Delegate,
means
this
yes,
one is a recommendation of the Virginia Bar
Yes.
Association, Real Estate Land Use Section, and Boyd Graves.
that is correct.
Okay, is there anybody opposed to this bill? Okay, it's been moved by Senator Perry and seconded by Boysko. We will report and re-refer the bill to Finance. Clerk will open the roll. Peek? Anybody got peek?
Oh, yeah.
Peek?
Got stuff coming.
Somebody got peek?
Ayes 14, no zero.
There you
Right,
go.
thank you so much.
Thank you, Delegate. All right, next up, Clark, and then Keys Gamara last. Delegate Clark, you have 34, which I thought, is this identical to the bill we saw last year?
Yes, I do have one line amendment, so I can make sure that it is identical to last year's.
Mr. Chair, that line amendment has not been distributed, but it's on line 30 after to the strike final and insert first.
Sir, can you read that again, Sabrina?
Sure. On line 30 after to the, you're going to strike final, so it'll be the, and insert first, so the date will be associated with the first invoice rather than the final.
Got it. So that they can't keep sending repeated invoices and extending the statute.
Yes.
Got it. So, Delegate, this is a bill that we passed last year 40-0 and got a veto, right?
Yes.
Okay. Has to go to Finance?
Move to report and refer.
Okay.
Doesn't need to go to Finance?
Senator, is there anybody opposed to it?
It doesn't have a fist.
Yeah, I'm sorry, we didn't move the amendment either. Senator Deeds moves and Senator Boysko seconds the amendment. All those in favor say aye. Aye. Anybody opposed? No.
Report and refer.
Let's make sure. Is there anybody opposed to it? Doesn't look like it. Senator Deeds moves, a bunch of people down there second, to report and refer the bill to Finance. Clerk will open the roll.
Senator, ayes 12, noes 3.
Oh, now that it gets a veto, you're
Usual
opposed.
three.
Okay. All right.
Thank you, Mr.
All
Chair
right.
and members of the committee.
See you, Delegate Clark. Yeah. All right. 171, Keys Gamara. Make sure you hit the sign-up list next time. I've seen you out there where your name wasn't on the list. I have to call the people on the list first and then. Got it. Okay, so you've got 171, electronic signatures, Boyd Gray's recommendation.
Correct.
That was a bad word to Senator Peterson when he was here. Why don't you explain your bill real quick?
Okay. 171 seeks, House Bill 171 seeks to modernize receipt of documents and legal proceedings. The bill clarifies that an electronic signature or digital image of a signature shall satisfy the requirement in current law that every pleading, motion, or other paper of a party be signed by at least one attorney of record. This bill is recommended by the Boyd Graves Conference.
Second.
All right, anybody opposed? All right, it's been moved and seconded. We report the bill. Open the roll, please. What, MJ? What? Okay, there we go.
Ayes 15, no 0.
Okay, thank you, Delegate. I'm sorry you had to wait so long for that 30 minutes of fame, 30 seconds of fame.
It was worth it.
Okay, I think that completes everything, right, guys? That's it. Okay. All right, committee will rise.
Senate of Virginia, Richmond, Virginia.